All right, this is Florida attorney David Coberline talking about Moore's child support case law. This is out of Texas, and the interest of DH modification of child support requires evidence. If you'll see, this is also related to Melton v. Toomey, because this case actually cites Melton v. Toomey. I'll have that case in the description. So, one of the things we commonly get asked about child support cases is how do I modify? Well, this is an interesting case because there was a settlement agreement tied to this one. Okay. And again, I'm not licensed in Texas. This is my lay opinion. I create this information for people to take and have a discussion with an actual licensed attorney in Texas. So to me, this is for people who are like, I want to get some background information before I go and meet with an attorney so I don't sound like don't know anything. And I want to make sure the attorney's giving me the straight skinny. Okay. So for anybody who just was paying attention, you just heard terminology from the South and from the North, um, and all abouts. And I have a slight Southern accent coming out of Florida. All right. So of course, this material is not legal advice, nor does it create an attorney-client relationship. Really, it's just for greater discussion of lay analysis. So basically, I'm not talking about anything that you can necessarily use in your own self-representation. Please do not represent yourself using this information. It's not going to help you do that. It will only help you develop questions and ideas to raise with an attorney when you're just having a conversation during a free consultation. How do you get a free consultation? Plenty of attorneys out there will give them call, ask, make sure it's free ahead of time. You don't want to get hamstrung. Say, hey, can you email me a confirmation of our appointment? And can you also please reiterate that it is a free consultation? I won't have to pay you anything unless I hire you. Thank you. Don't want you getting sideswiped when they go, oh, okay, now you can pay me for my time. I was like, no, that's not what we discussed. All right. So, some of the things here, and I like to look at this case because when I'm looking at the substantial material change in circumstances that typically that have to occur for a modification of child support, and we see that in Melton v. Toomey. So in here, I like to look at this as instead the father relied solely on her change of income, the mother's change in income, and they cite to this case Downey v. Downey, where basically, if you offer no other evidence of but income, then you really can't get a modification, because really they're looking at the financial circumstances of not only the people paying but also the child, because financial circumstances can increase, they can decrease. Kid might need more medical care. The kid might no longer need after, if your kid's 14, they don't know might not need to go to after school care anymore. All right, if it's just to sit around and be hanging out with other kids, well, they may not need that. It might not be in their best interests. And again, something else you're going to need to be aware of is typically when you're seeking a modification, from what I've read from the case law, for you to discuss with an attorney you're having a consultation with, is what serves the best interest of the child. Okay, that's a key crux. And you paying less doesn't necessarily serve their best interest unless you're going, well, hey, look, I'm going to go put it in their college savings account, which that's a whole other headache. And that's not what we're discussing here. And again, I'm not going to say you can use that basis, but that might be one you might want to discuss with the attorney. Well, hey, look, I'd rather put this money in my kid's college savings account because I'm pretty sure the other parent isn't using it for anything productive. Well, that's something to discuss with a lawyer. But really, this is a case that stems from a divorce in Texas. Okay. So, one of the other things I take from this is if you're going through a divorce and you know you're going to be paying child support, you want to make sure it's documented in the evidence what the financial circumstances of the parties were at the time of the end of the divorce and possibly in the settlement itself. Okay. So you want to go, hey, look, at the time of divorce, I was earning X. Since then, I'm earning minus X. It's a substantial change. I can't pay what I used to pay. I can't take care of myself, yada, yada, yada. All right. I can't afford a car and pay child support. And if I can't afford a car, I can't go to work. Those to me are going to be grounds, okay, that you'd want to discuss with the attorney and go, hey, man, is this a material change in circumstances? So that's part of what we get into. All right. Now, one of the things I did love in this is you look in the court opinion, there's this word eliminate. The father wanted to eliminate his child support duty, is what I read. Don't hold me to it. All right. Virtually no judge is going to look at that and be happy about it, at least in Florida. In Texas, your mileage might vary, but I would be surprised if a judge went, "Oh, Mr. So and so, you want to eliminate your child support obligation? Why should we do that? How's that in your child's best interest?" So, and these are just some of the things to discuss with the attorney. Okay. So I like this case. I'm going to put the link to it. If you go to and you visit it, you can read the exact case law opinion that's on scholar.google, which to me is virtually the same as Westlaw and LexisNexis. Don't hold me to that, but I stopped using Westlaw and LexisNexis because of Google, because it's virtually the same thing and I didn't have to pay for it. All right, so you can read the case opinion. There are other bits of law in there that are going to be relevant. So that's it for my coverage on this case. I think it's a good case to talk about your lawyer with. Talk about with a lawyer. All right.